Good morning. Good morning. We've got some feedback here. If somebody could mute them. Good morning. It's 9 a.m. on May 13th, 2026. This is a meeting of the New Mexico Oil Conservation Commission. My name is Chair Albert Chang. I'd like to call the meeting to order. Could I get a roll call from the commission clerk, please?
Yes. Commissioner Ampoma,
Present.
Commissioner Bloom,
Present.
and Commission Chair Kang.
Present.
Okay, we have our quorum.
Thank you very much. With that, I'd like to turn to the draft agenda that's been circulated. Commissioners, do you have any questions, comments, concerns?
No, Mr. Chair, the agenda looked good.
May I have a motion to approve the agenda if that's the case?
I so move.
Mr. Chair, second.
Thank you very much. Any objections? Hearing no objections, the agenda is approved. The first substantive item on the agenda is the approval of the minutes from the meeting on March 4th, March 10th, and April 9th of 2026. I'll open the floor for discussion for commissioners on those meeting minutes.
Mr. Chair, I reviewed the minutes and they look good to me. I would move to approve unless there's any other comments.
Mr. Chair, I do second.
Moved and seconded that the minutes from OCC meetings of March 4th, March 10th, and April 9th be adopted. Any objections? Hearing no objections, so approved. Moving on to the pending cases, zipping through the agenda items here. The first case on the agenda today is consolidated cases of Goodnight Midstream and Empire, New Mexico. Cases numbers 24123, 23614 through 23617, 23775, 24018 through 24020, and 24025. I will start with Empire, Empire's the party that's filing the motion here. Actually, give us 1 second.
Oh, yeah, Mr. Chair, I'll sit this one out and I'll note that Balin Lampkin is online. He's been the designee of the Commissioner of Public Lands for this case.
Thank you very much. We'll have the record reflect that for the purposes of these consolidated cases for Goodnight Midstream and Empire, that the commissioner sitting is Commissioner Lampkin. All right. Are the parties here for interference? Yeah.
Thank you. Corey Waymeyer of Santoyo Waymeyer PC here on behalf of Empire. I'm joined by co-counsel Dana Hardy of Hardy McLean, and we're ready.
Thank you.
Good morning, Mr. Chair. Commissioners Adam Rankin with the Senate Bay Office of Holland and Hart appearing on behalf of Goodnight Midstream.
Thank you.
Good morning, Mr. Chair, Commissioners. Chris Melander on behalf of OCD.
Good morning, Mr. Chair and Commissioners. Miguel Suaza with the New Mexico Office of Beatty Wozniak, appearing this morning on behalf of Pilot Water Solutions, SWD.
Any other parties in this case with us today? Nope. Great. I will turn to you first, Mr. Was Waymeyer?
Yes,
right?
sir.
Yeah.
Thank you.
However, but if I could ask that, I have some questions about whether this is procedurally proper in front of us first, and I'd like to address some gateway issues before we dive into merits questions. So I think we've all seen the briefings where questions were raised as to whether we even have jurisdiction to hear this case, whether it's procedurally proper in front of us under NMAC 1915-4, or at least that's my question. I don't know if that was raised by any of the parties, but because we've had a hearing, we've had a rehearing. So if you could help me understand whether and or how this is properly before the commission, that would be helpful.
Absolutely. So at slide 6 of the handout, we've provided the authority for the commission's jurisdiction to go forward today on the motion of Empire, specifically Rule 1074Q, which provides in pertinent part that upon motion, the district court may stay enforcement of the order or decision under review. So even though there has been an appellate proceeding commenced, there has been no stay whatsoever in terms of the underlying proceeding. And so as a procedural matter, there are mechanisms to stop further enforcement or action by the commission, and for that matter, by OCD. None of those have been availed here by any of the Goodnight Group or Empire Group. And so this proceeding remains ongoing. In terms of the case authority that we provide there, we rely on the High Mesa General Partnership versus Patterson case. And the quote there at the second bullet point being the right to decide whether they want to ask the court to issue a stay and stop the administrative process while the appeal is pending is a prerogative of the parties. No parties has made any such request here. With respect to the Kelly Inn case that I believe forms the foundation of the Goodnight position that somehow the commission at this stage is divested of jurisdiction. That court expressly held, quote, a pending appeal does not divest the trial court of jurisdiction to take further action when the action will not affect the judgment on appeal and when instead the further action enables the trial court to carry out enforcement of the judgment. So this is not getting into the law of the case, which was a separate argument that is advanced by Goodnight. But just from a purely jurisdictional perspective, obviously here, OCC and OCD have ongoing obligations to prevent waste, to protect correlative rights, to administer the orders that have not been stayed. The motion that we've filed that we've brought to OCC follows the OCD implementation order. And basically, as this remains ongoing, we want the OCC to have an opportunity to look at the implementation to make the determination as to whether it's within the spirit and the letter of precisely what OCC on review and its two orders directed happen here. So those would be our authorities for the ongoing ability and in fact duty of OCC here to revisit not revisit, but to ensure enforcement during the interim of its two orders.
Okay. So are you, for Rule 107, 1-074Q, I don't dispute that the district court can stay enforcement of an order or decision under review. Are you suggesting that that applies to, that we could adopt that rule in all? I guess I'm trying to figure out the relevance here of 074 to us.
Yes, the point of 074 is that there is a statutory mechanism to stop reviews and stop implementation of orders at this OCC regulatory level. No party has availed itself of Rule 74.
I see. Okay.
To stop that. So
At the
there is
district
a
court.
mechanism if Goodnight chose to seek that happen at the district court. They haven't done that. And so of course, the OCC is not only entitled, but obligated to go for under its mission of protecting correlative rights and avoidance of waste.
Right. Okay. But both parties here, not all the parties, but both Goodnight and Empire are appealing the commission's order, right? So it seems so why shouldn't the commission, if nothing else, to preserve administrative economy, hold this in abeyance until we have some further clarity? I mean, if both parties feel that the commission may have erred in its order to begin with, why are we revisiting whether or not a order that at least multiple parties have argued is at least ought to be modified, right, to some extent? Why would we be, I guess, reviewing this issue at this moment in time?
So there's two answers to that. The first answer, I'm not going to stand here and tell Dr. Ampoma or Commissioner Lampkin what they intended in the initial orders or yourself, Commissioner Chang, on what you intended on the second order.
Sure.
As some of the chairs have changed as this has gone on for quite some time. I'm not telling you what you intended in your order when you said that the existing injectors are quote unquote suspended. But in light of the manner in which OCD chose to implement the OCC's orders here, We still think on behalf of Empire that this is a grievous enough situation that it warrants bringing it back to ensure that, at least in terms of the interpretation of what suspends means, the OCC would be in agreement with what OCD has done here. And so the first of the two reasons to answer your question is this comes back to everything that Empire put on over the course of 18 days of testimony. The waste is occurring now. The water is not being confined to the injection interval in the San Andreas. That has been found in the orders. It is migrating to the Grayburg. The Grayburg is in existing production. And so that would be the first one, is that we do not believe that the OCD's manner and method of implementation here honors the OCC's decision after 18 days of testimony to suspend the permits. The second one, though, is that under the OCC's two orders, we have a 3-year deadline and clock ticking on us. And so Empire has taken that very seriously. And as you say, why wouldn't we just pause to see what happens at the district court review level? The first answer to that is avoidance of waste, which is our frontline position. The second piece of that is that in this interim, with no stay having been entered, we have a 3-year deadline ticking. And as a practical matter, we discussed this in the papers, the idea that we would have to go back and amend the water flood unitization order. I mean, this is a years-long process. If we are stuck with OCD's implementation decision that we have to amend the water flood order, there's no way we can do that in 3 years. And without speaking for the commissioners, I don't think that's what was intended in the orders. Additionally, the Form C-108 issue that is permeating, this is not an injection well that we were seeking to go in as part of this 3-year pilot to bring data back to the commission. And I completely understand that Dr. Mpoma was looking for, and Mr. Lampkin over the 18 days of testimony are saying, we love the core. We love direct evidence. We love science. We love data. Bring it back to us in 3 years where we have a more informed record here and we can make a decision on permanent suspension and permanent revocation as opposed to the 3-year temporary. If we have to go through this C-108 process and the hearing, and we know Mr. Rankin will be able to confirm for you that Goodnight's going to object to a C-108 and it gets in the hearing. There is no possible way that this can be administered within 3 years. To be able to come back to the commission with harder data, to have the science discussion that Dr. Mpoma and Mr. Lampkin found wanting. So
Okay.
the 3 years our clock is running on the 3 years. We've received OCD's decision. None of this has stayed. Something has to happen here at the OCC level because there's a friction here, irrespective of what the district court does on review. There's no way that the commission's decision on this can be honored.
Okay, but you haven't asked for a stay from either this body or the district court. So if you're concerned about the timeline, I guess I'm wondering why that wouldn't help me square that, I guess.
I'm not trying to be obtuse about this, and we respect the OCC's decision. But the first answer to why we're not asking for a stay is because what I said very first out of my mouth and what we said for 18 days in the hearing. It is of utmost importance to Empire that the injection stop as fast as it can stop. In Empire's estimation, this should have stopped a long time ago. In Empire's estimation, it should have never started in the first place. This is a unitized unit that, pursuant to the 1984 unit order, only Empire and its predecessors had the exclusive right to operate within. And so a stay does us no good, because if a stay is ordered, the injection continues that should have never started in the first place and certainly shouldn't be continuing today. And so Empire has no interest in delay. It's being harmed by the delay right now. We want to move forward. We want to bring the commission back the data that it asked for in its two orders, but we can't do it under the framework that's been created by OCD.
Just two more questions, if that's okay. If you can help me, because we're trying to be consistent across a whole number of cases, and many parties in other cases oftentimes also ask for repeated hearings, even after they've had their de novo hearing, after they've had their rehearing on the after the de novo hearing. So I'm trying to make sure that I'm drawing some sort of workable boundary, not just for this case, but also other cases, so that we don't end up with hearing after hearing after hearing after hearing in this never-ending cycle that never gets to some sort of decision, right? That then obviously could be taken to a higher forum. And so I think I'm going to need a little bit of help under NMAC 1915-4 on whether or not, once you've had your de novo and your rehearing, how do we get you procedurally to yet another hearing that discusses at least somewhat the merits of the decision here? And to the extent that if you're not seeking to relitigate the merits and seeking to relitigate, or maybe merely seeking to review how the order is being implemented by the division, that feels to me like a writ of mandamus by another name, and that would be an equitable remedy. And I'm not so sure that we have equitable powers in this forum.
I'll try to take that down in pieces first, so that the position of Empire is perfectly clear here. We are not before this commission asking for one change of one word in the OCC's two orders. We understand the order. We understand what the OCC
I gotta
decided.
interrupt. No, come on. You're asking to go from suspension to revocation. That is what you are asking for, a change of verb.
And Mr. Chandler, I'll try to address your comment too. In the motion that's presently before the commission, it is not a permanent revocation that's being asked for. We understand that we only have 3 years of suspension. That is what the commission decided. What we're before you on is trying to figure out how, in light of the commission's clear decision that we have 3 years of suspension, in whatever manner that ends up being implemented, how can you possibly square that with Empire's ability to go forward and execute the pilot, particularly in light of the idea that we would go through the 108 hearing process and the process of hearing to amend the water flood unit. And so the OCD in this instance is only can only act through and at the direction of the OCC's two final orders here. We're not quarreling with the verbiage of those two orders. It is Empire's position, I believe correctly, that what OCD has done here has strayed in an ultra-virus way beyond the four corners of the two orders that the OCC actually issued. And to your point, Commissioner Chang, in terms of a continuing relitigation of the merits, again, Empire does not ask for a change of one word out of the two final orders here. That is obviously up on appeal. This is not a mandamus ask. This is the first time that the OCC has been presented with the actual four corners of what OCD says its implementation here is going to be. And there is no way that the four corners of what OCD decided as the implementation could possibly be squared with the 3-year timeline to come back with data at the conclusion of the pilot program that OCC has ordered. There's absolute friction between those two things. And we believe that the correct procedural mechanism would be to bring it to OCC. The second piece is that as you talk about exhaustion of administrative remedies to make sure that something would be right for a district court review, the OCC has never looked at OCD's implementation correspondence and direction. And so I think the commission should at this juncture step in and give the relief that we're asking for in terms of the proper implementation that OCD should have implemented. But if it doesn't, at least at that stage, we have a clear record in terms of the OCD's implementation. At that point, we have an exhaustion of administrative remedies, and it would be something that would be right for a district court review.
Thank you. Before I turn to other parties, commissioners, do you have any additional questions for Empire, at least on whether this is procedurally proper in front of us before we get to the merits?
I do not. Thank you.
Commissioner Lampkin?
I do not either. Thank you.
Thank you.
and Ms. Hardy, may I just have 30 seconds to just get this all into one place? So if, for example, the implementation order, maybe the commission doesn't find it this stark, but if the OCC in its two final orders says direct green light and the OCD implements red light, clearly there's a divergence there and incompatibility in which they've strayed beyond the directive of OCC. And so the question then becomes, what procedural mechanism is available to Empire to address that situation? And if the world exists as Goodnight urges, there would be no procedural mechanism available to Empire after we've spent 18 days of testimony.
Well, or at least the question would be whether you'd have to take this directly to district court or whether this would be here, right? So really, it's a question of which forum.
That's correct. And if I were sitting on the commission, I would say, why didn't you bring it to me to at least look at it just one time? We're not asking that you look at it twice, but this would be the first time, this is the first time that the commission is ever reviewing what OCD has put out there as its purported implementation.
Got it. Okay. I'll turn to Goodnight. I have a feeling you have a different perspective on that.
I do. Thank you. A couple of things I just want to point out out of the gate that the commission didn't guarantee Empire the right to do an ER project. It didn't say you can do one. It said you have the opportunity to go forward and apply for one. Okay. That's what they said. That's what the order provides. And they said, the commission order, and I don't mean to tell you what you said in your order, but the commission says that to do so, you have to follow all the rules and regulations that are applicable. Okay, that's what the order says. In addition, it delegated authority to OCD to implement. So that's the context that we're operating here within. The commission at the time it issued this order understood its rules and the requirements for anybody that wanted to implement an EOR project that was subject to a unitization order. Empire knew the rules 2 years ago in their briefing to the commission. They understood and they represented to the commission that they knew they were going to have to amend the governing orders of the unit in order to implement an EOR project of any kind. So that's the context that we're working within here. As to the propriety of the procedure here, I do have a couple slides that I want to show as well. You heard Mr. Waymire make the remark that they're here today to ask the commission to revisit, and then he corrected himself. But that's exactly what they're here to do today. They're asking you to revisit your decision because they bring forward no new evidence, no new facts, no new claims. They just want you to reconsider what you did. The question is whether it's proper. There's two issues that they're bringing forward to you today. One is whether or not you should immediately shut in Goodnight's injection. That issue is on appeal to the district court, no doubt. Okay, that the same exact arguments and facts they re-argue here in their briefing are exactly the arguments that they raise in their briefing to the district court. Same exact arguments, same exact position. The first issue, in my view, because there are no new facts, no new evidence, is on appeal with the district court, and there's no basis for the commission to take that up here today. The second issue is whether the commission should modify the division's directions on the implementation of the commission's orders. That issue was squarely presented to Empire in the first order that was issued. And again, on the rehearing, they did not appeal it. It was not appealed. They did not appeal the fact that the commission fully delegated all authority to implement this order to the division. So that issue has been waived. Now I'm going to talk about a different way that they can go about this, but to bring it up now and with the commission and seek to go right to district court is not proper because there's no order from the division. There's guidance from the division. What we have is a letter providing guidance to Empire about how to proceed. It's simply a letter. It's no order. To be here before the commission, there are two ways that you can get here. Okay. Either there has to have been a hearing in front of the division with a hearing officer, which would give Empire the right to a de novo appeal to come back to the division, or the division director can request that the matter be heard directly by the commission. Those are the only two ways. Under the commission's order, the commission delegated authority to implement this EOR project under the rules and regulations and requirements of the division to the division. Empire received guidance from the division on how to go about doing that. Rather than ask for a hearing to argue over whether that's appropriate or not, they've come back to the commission without going through the proper procedural steps to actually get an order from the division. So this is an advisory opinion here. They're trying to get an advisory opinion from you without actually getting an order from the division. So there's no basis for us to be here in front of the commission at this time. We don't have a de novo. It's not a de novo. We don't have a hearing, an order from the division. All we have is guidance. And the guidance follows exactly what the commission laid out. Apply the rules. In their briefing, Empire cites to a case, as far as I can tell, it's the only instance where there was actually any injection without an order under C-108. It lasted for 2 months and the operator injected 50 MCF of gas. But under the regulations that govern and which the commission is bound to follow, operators are required to file and get a permit for any injection for EOR projects. They're required to go to hearing on any EOR project. And they must file a C-108 for any injection project. In the one case that they identify where that wasn't the instance, within several months, that operator was required to go to the division to get a hearing on a full C-108. And it was for an injection permit for an EOR project in a unit where the operator wasn't sure if they wanted to go forward with an EOR project. They weren't sure if it was appropriate or commercial. And so they were pursuing a pilot project within a statutory unit and were required to go to hearing, just as the division is requiring Empire to do here. They're required to file a complete C-108. They're required to get an injection permit for a pilot project, and they were required to go to hearing. Same exact situation. So here, again, Empire is trying to short circuit the process. They're trying to go right to district court to appeal the division's implementation of this order when it wasn't challenged in the first instance. And it's inappropriate. They should first go to hearing before the division, get an actual order from the division on what they're being required to do, then come back to the commission to challenge that before they can go to on appeal. Now, the last thing I want to say about this is that the one thing that Empire has in their control, for sure, is their ability to get into compliance with division rules. From the beginning of this proceeding, more than 2 years, they have been out of compliance with the division in their inactive wells. Under the rules that guide implementation of EOR CO2 projects.
So I'm going to interrupt. Like,
Yeah.
what does this have to do with what we're here for? I mean, how many years are we going to spend on rabbit holes? So get back to what we're here for.
We're here to understand whether or not Empire can go forward with any of these complaints. And they've done nothing to put themselves in a position to do what the commission gave them the opportunity to do, which is to go forward with an EOR project. For the last 2 years, they have not addressed the one thing they have control over, which is the inactive wells. And they're asking you to give them the opportunity to go do this EOR project when the one thing they can control is their inactive wells, and they haven't addressed that. They cannot go forward and get a permit until they do that. And so we're here arguing about this when they haven't even done the one thing that they have control over. So based on that, again, because of the procedural issues, because they waived this argument about implementation, and because they haven't actually done the one thing they can do to get ready for an order or implementation of this project, the commission should hold this argument in this issue in abeyance and not act on their motion. Thank you.
Thank you. I'd like to start with I take your point or at least I'll take under advisement your argument that the division's guidance is merely advisory at this point, right? But I do want to ask you a question about Empire's due process rights too, or any party's due process rights, right? So let's just, for the sake of argument, let's say that to take the extreme example that Empire provided, let's say the commission issued something that says green light, right? But the division went ahead and did red light. How can the commission ensure that there is no incongruity between what the commission has ruled on versus what the division has done. Now, whether or not we think that is in fact the case here, procedurally, how would we review that if there is a concern that the division is acting in a way that is incongruous with a commission ruling? Is there an exhaustion of remedy issue, or is the remedy to go directly to district court? Has this issue been, I'm relatively new on this commission. Has this come up before?
Well, let me just start with the initial premise. The due process is laid out in the division regulations of governing adjudications. They got a guidance letter from the division on how to proceed, which is to follow the rules, amend the order that governs injection in a unitized interval. What they're asking for is for the commission and division to authorize them to go forward, inject fluids that haven't been authorized for injection into a unitized interval, to allocate production from a unitized interval where that is in discord with what the actual governing instrument provides for. They have to amend those instruments. So the process here is for them to go forward, submit the materials, present to the division what they want to do. They have not yet said to the division what they want to do with their project. They haven't presented anything. So go forward, present your project, find out if the division is going to approve it or not. And if they don't approve it, then you can appeal it. That's the process. And if they have concerns about the way the division is proposing to implement, then ask for a hearing now. But that's only going to delay the process. If they really are under the clock, fix your inactive wells, go forward with an application to get your EOR project approved. Here, we're wasting time with something that has nothing to do with what the opportunity was that the commission gave them.
Commissioners, any additional questions for Goodnight?
No, Mr. Chair.
Commissioner Lampkin? Commission Chair or Council, I'm sorry.
I have questions for OCD if they're given a chance to talk.
Mr. Swazo or OCD, which party? Doesn't matter to me which party wishes to go first. OCD?
I would like to proceed, Mr.
Please.
Chair.
Please.
All right, going back to your initial question, which I think is a valid one. You're right, the parties didn't address it thoroughly or really at all in their pleadings. You asked about 1915 for NMAC. And from OCD's perspective, since we filed our pleading and the briefing packet was complete, we took a second look at this, and 1915 423B, from OCD's perspective, is a key provision here. The reason why is it addresses stays of division or commission orders, and there are two methods that can be accomplished. A party files a motion, and there's a briefing cycle. The OCC considers that. But on the third sentence, I think, and this is key language here, Director Chang, because this language empowers you to make this decision today, actually. It says the director may grant a stay pursuant to a motion for stay or upon the director's own initiative, which would be a conference of power upon you to make that determination. Now, stepping back for a second, there's been discussion, of course, about the issue of the stay in district court. And the focus has been on district court because that attenuates it from being an issue here. And that's an attempt to kick that down the road because we've obviously got appeals pending. Curiously, though, the Kelly Inn case, when you read, for example, on Empire's page 6, pending appeal does not divest the trial court jurisdiction to take further action when it will not affect the judgment on appeal. And when instead the further action enables the trial court to carry out or enforce the judgment. Well, the inverse of that would also be true. And in this instance, that would mean you do actually have the power to issue a stay here today. I think the key issue here, aside from that, is that you asked about incongruities and between OCD action and the OCC order. If a ruling were to be held in abeyance today, followed by a stay of OCD's implementation letter, since the crux of the appeal focuses on, at least from Empire's perspective, that there was an error in determining an immediate shut-in was not necessary or left to the discretion of OCD, this decision, if held in abeyance, ultimately may not even need to occur, ultimately, because the appeal may well render this issue moot on its face. And this would be a practical, very straightforward position. Now, I do need to note here, Empire's been very vociferous that it's not interested in delay, but I think some of the behaviors indicated the contrary, because one of the first things OCD asked for is a summary of the project scope. Empires provide nary a cartoon or a document to OCD to demonstrate anything that it intends to do. So the whole issue of substance is, it's not really even discussable yet because nobody actually knows what Empire intends to do. This has been a delay. There's tactical delay in this. So that's why OCD doesn't think that a stay of the implementation by OCD poses any actual problem. Empire's done nothing to date. Where's the harm here? And the answer is there really isn't any, because there's a tactical indication that there isn't one. And so from OCD's perspective, what OCD would encourage is hold a ruling in abeyance until the appeal is resolved and impose a stay upon OCD's implementation order. And let's get the major issues of the appeal resolved, which could well render what's before the commission today moot on its face.
Thank you. I appreciate the foisting of the sua sponte stay on me, but it doesn't seem like either Goodnight or Empire have asked for a stay. So I guess I'm not quite sure that I followed. How, you may have lost me there.
So Director Chang, you have the authority on your own initiative to impose one. OCD would not object to a stay of OCD's implementation letter simply because there are bigger issues in play that would render this moot. And it stands to reason a pause button here to allow the appeal to proceed, as both operators have sought, would in fact be appropriate, because it's a waste of administrative economy to make a decision that may well end up being irrelevant and legally moot in the main.
Okay. I don't have any other questions at this point, commissioners. Let me go through questions first. Commissioner Council or anybody?
Do you want me to go first, or I don't know how many questions? So the September order, paragraph 65 talks about a discussion, Commissioner Lankin and Mr. Wheeler, who's in the back here, from April 9th, 2025. Paragraph 65 quotes, question, I'm mainly speaking about if you guys had consent from the commission to establish an EOR project and you had committed capital from your company, what do you think the timeline is in reference to the Commissioner Mpoma's question about performing a pilot to verify that the ROZ is there and it's producible? Answer, if you just do a small pilot project and the commission requests it, I believe that we can get it and do it within that 2-year period where we're talking about drilling the wells and coring and then the analysis and everything of that to the present to the commission. Okay, so that's April 2025. I think if the department was there, and I think they were still in the case at the time, if they had gotten up and said, you know what, that's going to require a permit. And we can approve it administratively, but if Goodnight objects, it has to go to hearing in front of the division examiner. And if Goodnight still objects, we're going to have another hearing. I think the commission might have taken a different view. That one hearing is just going to beget another hearing, beget another hearing. I think the commission was trying to look for a solution. So tell me that I'm wrong, that Goodnight is not going to challenge everything and there's going to be beget another hearing.
So, Mr. Chandler, you're asking me to assume things here that I'm not comfortable assuming. Obviously, the case is in fact been very litigious. There's a lot at stake. It probably would stand to reason that Empire would object, but I can't predict party action. And I learned long ago not to make those assumptions and to go with the flow about what parties intend to do. It is regrettable that OCD didn't have that opportunity, but the record stands as it is at this point. And I think that what's in this letter, again, this is not an order. This is advisory in nature. And the first threshold issue is a summary of scope for the project, including the area, the pilot project within the existing EOR project and proposed use of existing wells or development of new ones. At this point, it's not even clear what Empire's intentions are whatsoever. We don't really know. The rest of this advisory letter assumes certain things that have yet to be demonstrated. And OCD does remain open to the idea that if a pitch was made by Empire, which has not occurred, there may be a different outcome ultimately. This was just the beginning. It certainly wasn't the end. And that's why that threshold issue was posed in the letter, is to solicit even a bare modicum so OCD understands what Empire's intentions are. And we don't know that. And we didn't know it then. We don't know it now. At the rate things are going, we may never ultimately know. So I'm sorry, but I can't really speculate on that. That's some dangerous territory, Mr. Chandler.
So the letter does say that they Empire have to amend the water flood order, which hasn't been touched in 25 years. Why would an carbon dioxide EOR have to do a water flood amendment?
I'll admit, I don't have everything lined up to this level of detail, Mr. Chandler. I would need to call witnesses to explain this in full. My understanding is this has to do with the various layers, the reservoirs, and how those would be impacted. Again, though, it sounds to me like you're taking the position that this is an order from OCD, and it's not. This is certainly subject to review. And while Empire wanted to change it on the front end, until OCD sees something, anything at all in any way, shape, or form, which we don't have, this is a prospective analysis of anticipated issues that may well occur. So this is not concrete. And OCD hasn't represented that it's concrete. But again, if Empire won't make its first move, how could OCD possibly make any further determinations? And the answer is it cannot.
So let me follow up. Empire, is that true? You have submitted nothing of the list of 6 things you've done nothing? Is that true?
So on May 1st of 2026, this gets to slide 16. On May 1st, 2026, Empire filed paperwork associated with the proposed ERR pilot project with OCD. The proposed well that was identified by Empire as part of that is the John D. Knox number 9 well. To put this into a little bit of geographic perspective, it's a bit northeast of the current injection wells. It was an area that was identified up structure. We heard all the testimony about structure and where we thought some of the best spots were. And so Empire has been doing the science to figure out which well, both from a geology perspective, as well as a mechanical integrity of the well bore and mechanical use of the well made sense. So that was the John Knox number 9. There was a form C103 filed to change the well bore configuration with respect to that. And it would be that well that would be proposed for the EOR pilot here. And it would basically be a huff and puff where approximately 5,500 barrels of CO2 would be injected. I think there's about a 20 to 30 day soaking period is what was outlined in the papers provided. And then there would be a period of after the 20 to 30 days of soaking, there would be a number of months of, I think initially it would be naturally pressured. And then after that point would be put on some form of artificial lift, I assume some kind of a pump jack. So that is what was proposed on May 1st of 2026. Again, it's for that John Knox number 9 well. It is not the intention of Empire to make that an injection well. That is not going to become an injection well that would be covered by Form C108. This would be a producer of oil. It would be stimulated with CO2. And so I guess the analogy that I would give here is, for example, if you're drilling a traditional horizontal well in the state of New Mexico and you permit that under Form C 101, You're going to put a lot of fluid into that well bore to fracture stimulate it. You could be looking at 400,000 to 500,000 barrels of fluid that would go down as part of stimulating, and then you would produce it back. In this instance, this would be far less than 400,000 or 500,000 barrels of fluid that operators are putting down on horizontal wells right now. It would be about 5,500 barrels of CO2. And so this is explained in our papers, but as you talk about pilot project, OCD jumped the gun here in the implementation and directed this broad scale, what is in effect a commercial project, actual commercial production going way past a huff and puff or pilot stage. And that gets into the water flood, which again, your questions is exactly what my client who just wants to produce its unit in terms of the San Andreas is going through is why on earth would we go through the hearing process to amend a water flood? Why would we go through a hearing process that of course Goodnight's going to object to? And so as we interpret the order, and it's our hazard, if we come back at the end of 3 years and the commission looks at the pilot program that we chose to implement and says the data is not good enough, we bear the risk of that hazard and we understand that. But we think here between core analysis and the huff and puff in connection with the John Knox, which has been submitted on Form C-103, there will be enough data to bring back to the commission to show that it's technically recoverable and economically recoverable. So we disagree that we've done nothing. Additionally, as you step back, we were quite shocked to get the order, and there's been a suggestion now that it was advisory or a suggestion, and I did want to direct the commission to the actual verbiage of what we got in this. It reads as though it was set up to ensure that Empire would fail within the 3 years. And so, for example, the amend the water flood order is an example of that, but as is the Form 108 for a well that's only getting 5,500 barrels of CO2. But at page 2 of the implementation, I'm quoting straight from it, directions for Empire. For a CO2 EOR pilot in EMSU to be established, Empire must take the following steps to amend the existing order R 7766. This was OCD telling Empire what its pilot program had to look like and what Empire had to do in order to satisfy OCD with respect to the pilot. At the last paragraph, quoting from OCD's implementation, quote, be advised for the project to be successful, item 1 should be submitted within 12 months. With all deference and respect to OCD, OCD doesn't get to decide what a successful pilot program is. It's the OCC at the conclusion of the 3 years as we bring the data back from the pilot program that gets to make that decision, not OCD. And I would also note that at the time OCD gave this direction, it had not asked Empire, what type of a pilot program do you intend to execute here? Is it a huff and puff? Is it a single well huff and puff? Is it a multiple well with a true injector in the center of it that would be injecting fluids and would need to be converted to injector status under Form 108? We just got this. Additionally, this is in the files. We did ask OCD to revisit this implementation letter, and that was denied. There can't be any arguing about that. We asked to have discourse on this, conversation about it. That was denied in the correspondence. I think OCD in some of its filed papers pointed that out. So with respect to, I think the question was, have we done anything? The first piece of this is it even possible under this idea that we have to go to a hearing on the water flood? And is it even possible on the idea of the hearing on the 108 that of course Goodnight's going to object to? Is that even possible to do within 3 years? The answer is absolutely not, irrespective of what the pilot program looks like. If we're going through that, there is no way that can be done with 3 years in terms of going through the process that OCD is required, then actually executing and bringing it back. That is just a pure impossibility. But within the confines of what we have, if we can do this on Form 103, which there's prior precedent for, this is not an injection well. It's a huff and puff on the existing Knox well, which has the mechanical integrity for the particular project. We would be in condition there. Very likely, we would also conduct core analyses and other data to be back within 3 years. It's just not possible if we're, for no reason whatsoever, amending a water flood order and designating a well an injection well that's not an injection.
I'll just finish with this. So I'm completely objective. I have 7 other different clients that I have to get to this afternoon. So I don't have a bone in any of this thing, but I just want you guys to get to the facts. We've been here 50 minutes. Other lawyers in the back of the room with other hearings. So I feel like finally you're now presenting the scientists with some information. Looks like Mr. Moander wants to finish things up. Thank you for your time again. I don't have a dog in this fight. Let's just get to the facts.
I'll be succinct in my response. This is an interesting little ambush. I got to give Empire's counsel credit. They definitely pulled a quick one here. They filed their response on April 27th of 26, and this filing came in on May 1st among 30,000 other filings. They didn't bother notifying, for example, myself or Deputy Director Powell about it. They saved it for this hearing. That's interesting. It would have been helpful to address this earlier since we're on the 13th day of May. It might have changed OCD's position. It might have changed the nature of the hearing. So this is tactical decision making, certainly in OCD counsel's opinion, questionable, although clever. I'll give them credit for being clever. But I think going back to Director Chang, ultimately, is OCD here has provided a vector to resolve this issue for the interim and to let the appellate process proceed. And depending on the outcome, again, this may not even be an issue the OCC needs to hear about again.
We'll get to you, but Mr. Suazo, you haven't weighed in at all. Would you like?
I'm glad to allow Mr. Rankin to go before since everything's fresh in his mind and I can close up, and I will be short as I have been throughout this proceeding if that pleases the commission.
Much appreciated. Thank you.
It sounds like Empire is making progress towards submitting something to the division for the division to make a decision on the authority that the commission actually granted it. So why are we here? It's premature. They've got something submitted. Let's go forward. What they're not telling you, though, is what interval the John D. Knox is going to produce from. It's going to be producing from a unitized interval that's under the Statutory Unitization Act governed by the amended order. So let's figure all that out at the division. It's been delegated to the division, and they've got something now that the division can review, and that's where it should be. And if they disagree with the division's decision on whether that affects the purposes of the OCC, they can appeal it now up to the commission. But this whole motion and the whole day is premature.
Okay. I think we've exhausted, or we've at least had a thorough discussion on whether or not this hearing is even ripe. Commissioners, I will turn to you for your advice. Would you like to, so I don't think I'm ready to make a decision on whether or not it's ripe for decision today without further thought and further review, but I will take your advice, commissioners, on whether you would like to have arguments on the merits anyway, so that if you would like to get to the merits, we will have that on record. If not, I think my personal preference is to give more thought to whether or not this is even in front of us in a proper format before we get to the merits. But I want to open up for your thoughts, Commissioner Lampkin and Commissioner Mpoma.
Mr. Chair, so after listening to all the parties, I think the last discussion more or less threw more light with regards to the direction. Now, Empire has provided something to OCD. OCD has to look at it. And OCD is telling us that what they presented to Empire is not a stone. It's more flexible, right? So I don't think we are ready to really even get into the details of what is being asked. Thank you.
Commissioner Lampkin?
Yes, I tend to agree with the chair on this one. I don't think I'm ready to hear arguments on anything today.
Okay. In that case, I'd recommend that we, I guess, set this for us, hold it over, take the matter under, I would recommend that we move to take the matter under advisement and set it for at minimum a status conference or to revisit at the next month's hearing. Would that be amenable to any of the other commissioners?
My question will be, will OCD be ready to really discuss that? You know, because now I believe they do have new information that they have to look at.
Dr. Ampoma, I would need, I hate to do this. If I could have a few minutes, I could get some clarity on that. Right now, right now, I don't know if that's true. Our team hasn't fully looked at the application. We can obviously expedite it, but that could be, I don't want to delay this anymore either, because we've all had enough of this case. I can't guarantee we'll be ready, but I also, again, don't want to delay, and we would expedite review of this. It'd be a top priority.
And just to clarify, my suggestion is to take it under advisement, set it at minimum for a status conference, and then depending on whether or not the parties are ready to not necessarily guarantee that we'll proceed, but to at least preserve it as an option.
Mr. Chair, I support that. Thank you.
On behalf of Empire, we appreciate that approach very much. I think it was very helpful for my client Empire to hear today that it is not OCD's position, in fact, that this implementation order is an order, and that in light of the actual facts and program that Empire proposes for its own unit, they will take that on an expedited basis in good faith consideration. I also, for Empire, wanted to thank the commission. We certainly are mindful that we're blessed with an audience that does actually read the papers. We don't always have that opportunity. And we know this has been an incredible burden on your time. Mr. Chandler, I hate that we make you feel that we've come back for more bites at the same apple. It's something important to Empire, and I apologize if you feel like we're spending time on things over and over, but I think today's been helpful in terms of hearing from OCD on some things, and would look forward in the next setting. Maybe we'll have something productive to report.
Appreciate it. In that case, may I turn to one of the commissioners for a motion to take the matter under advisement and to set it for a status conference at the next commission meeting, or not at the May commission, at the next regular commission meeting?
Mr. Chair, I so move.
I second.
Any objections from commissioners? Hearing no objection, so adopted. Thank you all very much. Thank you all very much. I will turn to the next agenda item. I'll give the room a moment to reorganize itself. It's very busy.
Schedule.
Actually, yeah, that's fine. To give people time to set up, why don't we take a 5-minute recess? Good morning. Good. Good morning. If I could call the room back to order in order to keep us on time. Thank you all very much. I'd like to call the consolidated applications for hearings de novo from Desert Ram South Ranch and Pilot Water Solutions. This would be case numbers 26053 and 26082. May I please have entries of appearances?
Yes,
Yeah.
good morning, Mr. Chair, Commissioners, Dana Hardy on behalf of Select.
Good morning, Mr. Chair, Commissioners. Miguel Suazo, joined by my colleague, Dianza Valencia, appearing today on behalf of Pilot Water Solutions.
Mr. Chair, members of the commission, Matthias Sayer, joined by my colleague David Kermsey on behalf of Desert Ram.
Awesome. Thank you all very much. This is a status conference on the applications and consideration of the motions to dismiss. I will, if Ms. Hardy would like to address both motions together.
Yes, I would like to do that.
Yeah.
Happy to. Thank you very much, Mr. Chair. Here, by way of very brief background, Desert Ram and Pilot are competitors of Select who lack any interest within 1/2 mile of Select's proposed wells. Pilot operates SWDs across the state line in Texas, and Desert Ram is formerly known as NGL and is affiliated with Hydrosource, a company that sells and transports water for oil and gas production. Desert Ram states that it has freshwater wells 2 to 3 miles away from Select's proposed wells. Here, Desert Ram and Pilot are attempting to appeal the division's non-final interlocutory order that denied their intervention in an effort to circumvent the division's decision. And just given the case that was previously discussed by the commission, the Empire Goodnight cases, this situation is very different because there, the issue is whether the division complied with the directive of the commission's order. And here we don't have that. These applications should be dismissed because they are procedurally improper and would waste resources of the division and the commission. Neither Pilot nor Desert Ram identifies a single case ever before the commission or the division where this type of relief has been granted. And this is certainly not the first case where a party has been denied standing before the division. So I want to make a couple of issues clear at the outset. First, 3 of these cases were already heard by the division and taken under advisement, and orders are pending. As a result, Pilot and Desert Ram's request to reverse and remand the division's standing decision would waste resources. It would not conserve resources. They are asking the commission to require the division to hold a second hearing on the merits of those applications. And then presumably the losing party would seek a de novo hearing before the commission. So granting the request that these parties are making here would necessitate 3 hearings on the merits of the applications, which is a waste of time and resources for all involved. Second, Select is not arguing that Desert Ram and Pilot cannot file de novo applications after the division issues final orders. I think they can seek to do that at that point, and we would then litigate their standing before the commission. So really here, both parties fundamentally misunderstand the commission's de novo hearing process. They are conflating de novo hearings with de novo review. The commission does not exercise appellate jurisdiction over the division and does not conduct de novo review, which is an appellate concept that involves an appeal on the lower tribunal's record. Here, the parties claim prejudice from being excluded at the division level, but that claim has no merit because there is no appeal to the commission on the division record. Rather, the commission would hold a new hearing, a de novo hearing. So there's no prejudice to them from not participating in the division proceedings. If they were to have standing before the commission, and if they were to seek a de novo hearing after the division issues its final orders, they would have an opportunity to participate. I disagree that they have standing. We would certainly brief that, but but that's, I think, would be the outcome. So here, under the Oil and Gas Act and the Commission's regulations, the de novo hearing process applies to final division orders, not interlocutory orders. And Section 70-2-13 of the Oil and Gas Act states, and this is a quote, "When any matter or proceeding is referred to an examiner and a decision is rendered thereon, any party of record adversely affected shall have the right to have the matter heard de novo before the commission." The only reasonable interpretation of this statute is that the matter that is referenced is the entire case, not individual rulings within a case. Otherwise, parties could file applications for de novo hearing on any variety of matters decided by the division. That it could include denials of continuance motions that are coming up. It could include evidentiary rulings. If you construe matter as broadly as the parties do, that would be the outcome. And that's certainly not, I think, something that would benefit the commission or the division. It would delay proceedings. It would waste resources. So it's just simply not contemplated or permitted by the statute or the rules. In addition, under the adjudication rule 19.15.4.20b, the division director can refer cases to the commission, and that is what occurred with the Empire and Goodnight cases. But there's been no such request or ruling on that issue here. Rather, 3 of these have already been heard by the division and taken under advisement. There are sound policy reasons for the commission not to entertain interlocutory appeals, particularly here, again, where 3 of the cases have already been taken under advisement. Desert Ram and Pilot rely on the collateral order doctrine, which is a narrow appellate doctrine that allows immediate appeals from district court to the Court of Appeals. First of all, that doctrine does not apply to administrative proceedings. And second, it also only applies to appeals. And again, here, we're not talking about an appeal to the commission, although that's what they are asking for. Here, the commission has authority to grant de novo hearings. It's not an appellate process. Here, finally, there's no basis to stay the division's proceedings, which is another request that the parties make. Again, 3 of the cases have been heard and taken under advisement, and orders are pending. There's no reason for a stay. There is no reason to hold 3 hearings on the merits of each application. That would waste time for everyone. And a stay would harm Select. Select filed these applications in August of 2025, and its customers need the injection capacity provided by these wells. The hearings before the division were delayed for about 6 months as a result of objections by interest owners who actually did own interest within a half mile of the wells. And Select worked with those parties to resolve their objections, and the objections were withdrawn. So these matters were finally set for uncontested hearing in early February, and both Desert Ram and Pilot intervened or sought to intervene and object literally on the eve of hearing. So these cases were pending for 6 months before Desert Ram and Pilot did anything. So further delay of these cases, which is what they are asking for, would harm Select. There's no basis for a stay. The division should be allowed to issue the orders in the cases it's taken under advisement, and then these parties can file for de novo hearings, and we can litigate whether they have standing at that point. That's really in everyone's best interest. It would conserve resources of the division and the commission and the parties. And this is the process that's permitted and contemplated by the rules and the statutes. So the de novo hearing applications should be dismissed.
Oh,
thank you.
Thank you. One quick question. I think I heard you say, though, that Select agrees that Desert Ram and Pilot would be able to seek a de novo hearing at the conclusion, right?
I think that they could, and we would then litigate standing.
At that point,
Yes.
yes, understood. So from your perspective, is there any difference between us dismissing the de novo applications versus holding them simply in abeyance until the conclusion of the division cases?
I think that the reason to dismiss them would be that they are premature because the division hasn't issued final orders. So the division, in theory, could deny Select's applications. I mean, I don't know that that's going to happen.
Sure.
I hope it doesn't personally and for my client, but that's theoretically possible. So I just think that the applications are procedurally improper at this point and premature.
Right, but agreeing with you, if we were to agree with you on that point, why couldn't we simply hold the applications in abeyance until pending the outcome of the case at the division and then take them up? You know, either dismiss them because the case has been dismissed underlying, or take them up at that point. Is there a practical difference there for you? Between a dismissal and simply
Right.
holding it in abeyance?
I don't really think so, Mr. Chair.
Got it. Okay, thank you. I don't have any other questions. Commissioners?
No questions.
Council?
Just a factual question. When did Division Examiner Shakian hold the hearing? Was it May 12th, May 11th? What was it?
The hearing was in February. It was, I believe, February 5th.
I swear there was in the papers that he was about to hold the substantive hearing on this, but I guess I'm wrong. It was February?
So, okay, so there are 4 cases. 3 of the cases were heard and taken under advisement on February 5th. The 4th case is set for a contested hearing on June 2nd. And that is because Coterra, which owns mineral interests within a half mile, is objecting. And that is the Coyote SWD. But the other 3 have been taken under advisement.
Thank you. Mr. Sayer and Mr. Swazo, I'll let you guys flip a coin as to who wants to start first.
Good morning, Commissioner Chang, Commissioners. We're glad to go first. We have some slides with some of the statutes and rules just so they're front and center, because I think simply reading those, I think adds a lot of clarity to what the options and decision points are for the commission. So as you know, this is Pilot's de novo application for, the hearing examiner's February 25th denial order. And I want to walk through the statutes that Pilot relies on to oppose Select's motion to dismiss and to support Pilot's intervention. Next slide, please. Spacebar. Click on it. There we go. All right. So let's begin with the controlling. Is that better? No. Go. All right. Any echo? No. Okay. Let's start with the controlling text, section 70-2-13, and I'm going to quote that because I think every word matters here. When any matter or proceeding is referred to an examiner and a decision is rendered thereon, any party of record adversely affected shall have the right to have the matter heard de novo before the commission upon application filed with the division within 30 days from the time any such decision is rendered. The statute is triggered by a decision rendered by an examiner, not a final order on the merits. The legislature used the word decision twice, and it did not write into that language the limitation that Select is urging today. Now let's compare that to 70-225A, which expressly conditions rehearing on an order or decision of the commission. Section 72-13 contains no comparable qualifier. That omission is deliberate, and words must be given effect. No words, final merits order, no carve-outs, no participation orders. Next slide. Now let's move to the rule. The commission's own rule confirms this reading. Rule 1915-423A states, when the division enters an order pursuant to a hearing that the division examiner held, which happened here, a party of record whom the order adversely affects has the right to have the matter heard de novo before the commission, provided that within 30 days from the date the division issues the order, the party files a written application for de novo hearing with the commission clerk. This rule imposes one procedural predicate, and the order must follow a hearing the division examiner held, which happened. It imposes no finality of judgment or requirement. The commission could have added one when it adopted the rule. It did not. So the hearing examiner's February 25th written order denying Pilot's Rule 1915-411C reconsideration on substantive grounds is a decision issued pursuant to a hearing. Both the statute and the rule are satisfied on their face. And Pilot filed in time on March 27th within 30 days of that adverse ruling. So the rule itself confirms the statute's breadth. Next slide. So this is the timeline, just so at ease of visibility. The reason why Pilot did not object earlier is because we didn't know that the applications had been filed. And once they found out that these applications had been filed, which were refiled in January, that's when Pilot began examining this and decided to get involved. So since they got involved, our participation has been prompt and substantive from the start. January 28th, Pilot entered its appearance and filed a notice of opposition. On February 3rd, Pilot responded to Select's motion to strike and requested additional limited time. On February 5th, the division holds the hearing. Pilot appears through counsel. On February 19th, Pilot moves for reconsideration of the order granting Select's motion to strike. On February 25th, we got the order denying Pilot's reconsideration, and then Pilot filed with the commission for de novo hearing. So Pilot acted promptly and substantively at every step. Next slide. So if we step back and look at the statutory architecture one more time, the commission has concurrent jurisdiction and authority with the division to the extent necessary for the commission to perform its duties as required by law. Select's reading would functionally read this clause out of the Oil and Gas Act itself. Under Select's view, any hearing examiner order striking a party, excluding evidence, or terminating participation would be categorically beyond the commission's review. That construction strips the commission itself of the ultimate adjudicatory role and authority that the Oil and Gas Act gives it to or assigns to it. So commission review is not extraordinary here. It's part of the Act's structure. Now let's move to an order which we cite in our briefing. Next slide. On party of record status, the commission has its own precedent, Order R14097A, which applied the Supreme Court of New Mexico's Vanzi test. Under Vanzi, party status turns on whether the entity participated in a legally significant manner, not on the agency's label, which the court said was something of a moving target. And that is paragraphs 47 through 49 of that case. And in R14097, this commission applied that test and denied Amtech's party of record status because Amtech's filed no pre-hearing entry of appearance, presented no evidence or argument, did not appear at the division hearing, and entered the case only 22 days after the hearing, after the record closed and the matter was under advisement, and offered no excuse for the delay. This is the exact opposite of what Pilot has done here. Pilot entered its appearance. We went through the dates. It provided affidavits from representatives of the company and then moved for reconsideration. So Pilot in this case took every step required under R14097, which identifies as what's legally necessary for significant participation. And so exclusion cannot erase the right to review that exclusion. That's the whole point. Pilot's acted, we've been denied. We're asking this commission to reconsider and simply allow us a short window to provide our evidence of the impact that Select's proposals would have on Pilot's operations. Next slide. And I'm almost done with these slides. These are pretty short. So we provided some case law to support our position, and 4 New Mexico cases support Pilot's reading. The first one is the Burroughs case, which states that courts do not rewrite the statute. Courts do not add limiting words where the statute makes sense as written. Section 7213 says decision, not final merits order, and the court should not add what the legislature did not write, nor should the commission. The second is State v. Smith. The takeaway from that case is to avoid absurd results. Statutes should not be read mechanically where the reading makes the remedy illusory or produces an unreasonable result. Select's reading of the statute is a textbook example of that, because if we're allowed to come in after a final order is issued and we're granted party status at that time and allowed to present evidence, essentially that's a additional waste of resources not contemplated compared to if we're allowed to enter into the case presently and simply provide the commission evidence of how we think we're impacted. The third case is to effectuate legislative intent. Statutory construction must give effect to legislative intent, and 7213 operates as a real review mechanism, not a remedy that disappears the moment that it becomes necessary. And finally, we have Carrillo v. Rostro, which exclusion orders are functionally final as to the excluded party. So from pilot standpoint, we're effectively already facing a final order from the division examiner in our ability to enter into this case. So Select's reading of this that they're trying to compel you to support is circular. At the moment of exclusion, Select says no review is available because no final merits order has issued. And after a final merits order is issued, Select's own logic forecloses review because the excluded participant, in this case pilot and potentially Desert Ram, would at that point already been erased from the record and has no status to claim adverse effect at that juncture. So the remedy provided by the statute on the first slide, cannot evaporate the moment that it becomes necessary. So Pilot's request for relief to this commission is four things: to deny Select's motion to dismiss, to accept jurisdiction under section 7213 and rule 1915-423A, to set the participation issue for de novo review, and to grant Pilot's intervention. I can stop here unless, since Ms. Hardy brought it up, because notice and standing are two separate issues that I think need to be handled accordingly. I have a few points on standing itself, if you'd like for me to cover those, or I can wait till you have questions on the notice or the initial slides.
Yeah, let's one at a time. Any questions from commissioners or council?
No, Mr. Chair. No, Mr. Chair.
In that case, I'll turn to Mr. Say.
Thank you, Mr. Chair. And I appreciate Ms. Hardy's comments and appreciate Mr. Suazo's presentation. Those slides helped, I think, elucidate some of the important considerations in front of the commission. And I will try to not be repetitive because I think so much of Desert Ram's position was articulated by Mr. Suazo, but I did want to clear up a few points and emphasize a few points. One, Select argued that Desert Ram is a competitor. Desert Ram is not a midstream water entity. Desert Ram is an agricultural entity that owns and operates a robust cow-calf operation across multiple sections of land. As noted in the affidavit of Mr. Jerko, and as part of their operation, they own and operate dozens of points of diversion that are, water rights under recognized and issued by the Office of the State Engineer. And so while Desert Ram may have an affiliation with an organization, an entity that does manage water logistics, Desert Ram is its own entity that operates the land as an agricultural entity. And turning to some of the discussion about party of record, I do think that it's important, Mr. Suazo pointed to some of this, but when you look at the Vanzi case, I think it's important to identify that there were parties in the Vanzi case who ultimately were recognized by the court as parties and parties who were not recognized as parties. And I think when you take a minute and examine what those parties did and did not do, it helps, I think, shed a little bit more light on 14097, the commission's order, and on what has been in front of the commission today. In the context of the parties in Vanzi that were recognized as parties by the court, each, as the court noted, participated in the proceedings in a legally significant manner. So if we look at the procedural posture of the rulemaking.
May I interrupt you for a second?
Yeah.
I apologize for the interruption. Please continue.
No, thank you, sir. So again, looking at the parties who were recognized as parties by the court said that each participated in a legally significant manner. And if you look at, again, the posture of the proceeding, it was a rulemaking. And the role that those entities were playing in that rulemaking, they filed those filings that were appropriate to be filed by the parties that they were trying to be. They were trying to participate in the rulemaking, and so they filed advance notice of participation, named their witnesses qualifications, and other prerequisites related to their testimony. And when we look at the party that was not recognized as a party by the court, we see that party, they did not file a request to be heard. They did not intervene as a party. Essentially, they filed nothing. So no legally significant actions taken at all to represent their interests. And then when you look at 14097, Amtex looks a lot more like the parties in Vanzi that were not recognized as parties. Turning to the present case, what did Desert Ram file? This is important because given where the proceedings were, Desert Ram filed just about everything that could be filed to represent its interests. It entered its appearance, filed a notice of intervention, a notice of objection. It responded to a motion to strike. It then filed, once an order was issued on that motion to strike, a motion for reconsideration, coupled with an affidavit of sworn testimony, and then participated in a hearing on the motion to strike and the motion for reconsideration. And so I have a really hard time looking at what Desert Ram filed, lining it up with what was filed both in 14097 and what we see in Vanzi, and seeing how Desert Ram is not similarly situated to the parties in Vanzi that were recognized as parties as compared to the party that was not. Turning next to the collateral order doctrine, and we tried to mention this in our response, but Desert Ram is not arguing that the commission should adopt the collateral order doctrine as a doctrine of the commission. Rather, Desert Ram is inviting the commission to look at the collateral order doctrine as relevant guidance, which is certainly something that the commission can do. And we think it's useful to do so when you look at what the collateral order doctrine prescribes or invites the commission to consider. Specifically, was the decision, did it conclusively determine a disputed question? Does it resolve issues separate from the merits and effectively unreviewable after the final action? Ms. Hardy argues that, if the collateral order doctrine were relied upon by the commission, that essentially would open the floodgates for any non-final order on the merits to be brought to the commission. And I think there are some important limiting factors that exist in this case. First, looking at the collateral order doctrine and discussion of the collateral order doctrine, the doctrine exists to prevent irreparable loss of substantial rights, right? And so I don't think that if you could apply that doctrine in good faith and say that an adverse ruling on a motion to continue is a substantial right. And so if we're looking at a motion to continue or some other scheduling request that a hearing examiner or the division denied, would that be something that would then be able to be brought to the commission using the collateral order doctrine? I don't think that it's a colorable argument to say that's a substantial right. In this case, we're talking about participation in applications for shallow injection in formations that are not well understood, injection zones that are from a geographical horizontal, extent immediately below the aquifer that Desert Ram relies upon for its operations. So I think substantial right is there's a meaningful difference between what we're asking for as compared to what someone might be asking for in one of the arguably less substantial right situations like a scheduling order. And then second, I think this is important, Mr. Chair, the question you asked of Ms. Hardy about, so if we were to, could we not just hold this in abeyance and let the underlying applications move forward and then see if the parties at that point want to continue with this based on the outcome of the merits? I think it's important in considering that question to remember that when the division and the commission are hearing applications for a Class 2 well, that the division is sitting in a somewhat different regulatory posture than when it's examining, for example, a pooling case or a unitization case, right? Because we're not just talking about the Oil and Gas Act, we're also talking about and implicating the Safe Drinking Water Act and the state's primacy under the Safe Drinking Water Act in the UIC program. And what the UIC program and the Safe Drinking Water Act include is a non-endangerment mandate, right? And so I'm going to point to some language in our brief, but under the Safe Drinking Water Act, it established, apologies, this is why I let Miguel go with slides first. They're much more technically sophisticated. Okay, under the Safe Drinking Water Act, injection activities may not be authorized unless they are conducted in a manner that prevents the movement of fluids into underground sources of drinking water, especially where such movement may endanger drinking water sources. So in this case, if the applications move forward and the division were to authorize that injection, when there's a possibility that those injection activities could endanger drinking water sources, there is a very colorful legal argument that we've already run afoul of the Safe Drinking Water Act because you've authorized an activity that could endanger a drinking water source. And so allowing this to be heard now, I see you have a question.
Yeah, but that hasn't been ordered, right? Like you're asking for us. I mean, I can see the endangerment if there was in fact an order for us to stay, but there hasn't been an order yet because the proceedings are still pending and under review. Isn't that
correct?
True?
And if yes, Mr. Chair. And so if I understand the kind of hypothetical that you presented to Ms. Hardy, it was why not hold this in abeyance, allow those proceedings to move through to an order, presumably, let's say authorizing that injection, and then pick up our application for de novo hearing, or at that point, an application for de novo hearing on the merits of the final order. My argument would be at that point, we've now stepped into the place where the Safe Drinking Water Act says we shouldn't go, which is authorizing an injection activity that endangers sources of groundwater.
right? But if we were to stay those orders, if they were, because to Ms. Hardy's point earlier, for all we, hopefully not for Ms. Hardy, but for all we know, the hearing examiner could deny the application, right? So in which case, what an endangerment under Safe Water Drinking Act?
Fair. And so I suppose in that case, we would be, say, crossing our fingers that is exactly what happens, that those applications were denied and that we didn't have an endangerment of underground sources of drinking water.
I guess my question then is, shouldn't I hold off on the decision on whether or not to stay on until there actually is a decision from the hearing exam? Because at that point, I could, on the day that it is issued by a hearing examiner, if it is a order allowing the permit to proceed, it would seem like the commission still has the opportunity to stay it on that day and grant a de novo hearing or at that point, right?
Yeah, and I think your point is well taken. And so I'll finish with this. And I think you mentioned this at the April status conference. But if we were to pursue that path, I think two things become relevant. One, hopeful that the division, would be mindful of that and be paying attention to stay that order at that point. But two, if our applications for de novo review of the limited decision on standing, if the commission determines not to hear those, I do think that we would be establishing a precedent that a standing determination is effectively unreviewable. And I think also relevant, at least for the commission to be aware of, in the underlying case that is proceeding to a contested case in June, the city of Jal did recently file a notice of intervention. And the grounds for their intervention are almost identical to Desert Ram's intervention argument. And so far, no action has been taken as it pertains to their motion or their notice of appearance, entry of appearance. But certainly whatever the commission decides relevant to Desert Rams and Pilot's attempts to intervene and review of the decision to strike that intervention seems very relevant to the city of Jal's participation.
Sure.
And then just last point, which I forgot to clarify earlier, Ms. Hardy mentioned that Desert Ram had groundwater interests that were 2 and 3 miles away. Desert Ram has groundwater interests that are just over 1 mile away.
Thank you. So I think if I heard Ms. Hardy correctly earlier, and I actually tried to clarify this on the record just to make sure that we all heard it correctly, I think Ms. Hardy's has already conceded that Desert Ram and Pilot would have standing to seek a de novo hearing at this commission. It seems like the only dispute between the parties at this point is what time that happens, whether or not it happens all as part of a single de novo review at the conclusion of the division's case, or whether or not we can piecemeal and do it sort of in the more interlocutory posture. That seems to be the main crux of the dispute. I believe I heard Ms. Hardy say twice that she concedes that that the commission shouldn't end up in a place where standing decisions are unreviewable. Am I correct, Ms. Hardy?
That's correct. I think that Pilot and Desert Ram are parties of record that could seek a de novo hearing. I think we still would argue they do not have standing to raise objections to Select's applications. And I think
At that
that's,
time,
yes, at that time, yes, and we would litigate standing. But yes, I'm not contesting that they could file an application for de novo hearing as a party of record.
Right, okay, because presumably the argument is that if the hearing examiner erred in that determination, that one would like that to be able to be re-raised at a de novo in front of the commission, right?
Correct.
Okay. Mr. Swazo, would you do me a favor? Could you pull up the NMAC slide that you had up earlier?
Sure. The NMAC, I think it was slide 2 or 3.
Mr. Chair, while he's pulling that up, just follow up to your last question. As it pertains, it seems like if we were to pursue that route, it would be out of the concern for administrative resources and being efficient with those resources. Given that one of these cases has not yet proceeded to a contested case, it would seem a strange approach to being judicious about administrative resources to move that case forward anticipating an appeal of that case when the parties who would like to participate are sitting here now asking to participate.
I hear you. I'll address that point in just a second. I think we just had it up until we lost it again. I'm looking at this, there's a 30-day time limit there, right? Division enters an order pursuant to a hearing, provided that within 30 days of the date, the division issues the order. So I think, Ms. Hardy, I think it would be challenging for us to preserve these other parties of records' ability to appeal under, or to seek a de novo under this provision of the NMAC if we dismissed it and asked them to refile, which is why I'm currently inclined to hold it in abeyance so that they meet that 30-day requirement from the order on standing, right, and preserve that.
And Mr. Chair, I read the rule, when you look at it in conjunction with the statute, is meaning the final order of the division.
Okay. And then let me turn to the other question about administrative resources. I hear you. And perhaps this is selfish of me at the commission, but I'd like to preserve the commission's administrative resources. And I'm slightly less worried about the hearing examiner's time. And in the past, it has often previously proven useful to have parties have more time to meet, confer, hopefully mediate, resolve issues. And sometimes the building of a record at the division hearing examiner, that forum allows us, even though it's a de novo hearing, oftentimes here at the commission, we've been able to adopt at least parts of the existing record where parties have stipulated to it. That saves us the time of having to take all the witnesses and all of the procedures here. So my inclination is to my recommendation to my commissioners is that we exercise some of the broad statutory authority to manage our docket here, and to agree, I think, with all the parties that Select and Pilot would have the opportunity to seek a remedy through a de novo hearing, and to find that the collateral order doctrine does not apply in this case because Desert Ram and Pilot standing and the issues raised remain reviewable in a subsequent de novo proceeding at the commission, and therefore doesn't meet the effectively unreviewable test under the collateral order doctrine. But also to provide, but also to avoid multiple potential de novo hearings of the same case, and to try to have the hearing examiner do as much of the the sort of underlying work for us as possible. My suggestion is that we hold the applications for de novo hearing in abeyance until the conclusion of the proceedings in the underlying OCD cases, and that we make everybody unhappy by denying the stay, denying the request for limited evidentiary hearings as moot, and that if there are additional necessary factual development that needed to happen that did not get to happen at the in front of the hearing examiner, that we do that as part of the de novo hearing, if and when that does arise. And we would also deny Select's motion to dismiss the application. Deny Select's motion to dismiss. So that would be my suggestion. I think that probably makes all the parties equally unhappy. So that would be my suggestion for splitting the baby. I will turn to commissioners and see if there are any thoughts on that.
Mr. Chair, I do not have any objection to your suggestion. Thank you.
Mr. Chair, I also do not have objections to the plan that you outlined there. I did share some concerns that we're hearing initially about our Desert Ram and Pilot, both parties of record, should they not be satisfied with the orders that come out, and I think we have agreed that they are. And so with that, I would support your position on this.
May I ask a few clarifying questions? So the de novo request is held in abeyance. I get that. When a final order is issued, at that time, you're saying that if Pilot and Desert Ram proceed with their de novo request, they can present the evidence that they have been seeking to present to the division in front of the commission.
Yes.
But what I also heard, I'm sorry, that's a yes for the record?
That would be my understanding, yes.
Okay. And so you also said that you want to be mindful of commission resources and division resources. And is it your, I guess, direction to the division that they have at this point the discretion to reconsider whether or not Pilot and Desert Ram can submit their evidence and present their witnesses to the division? Or are we foreclosed from that at this juncture from the commission standpoint? And the only opportunity we have in this process is to present that at the de novo hearing that you have said is available to Pilot and Desert Ram.
Ms. Hardy, you're welcome to weigh in here, but well, I'll let you weigh in before I respond, I
Well,
guess.
Desert Ram and Pilot both already sought reconsideration of the division's decision, and the hearing examiner denied it. So I guess they could ask the division to reconsider a second time. I expect that request to be denied.
Yeah, I don't think we're giving the division hearing examiner direction one way or the other.
Okay.
I think Ms. Hardy's point, predictions may prove accurate, but we're not necessarily giving the division examiner any direction one way or the other. We're simply saying, we will take up your de novo hearing, including whatever issues that may come up, including other issues. For all we know, Select may want a de novo hearing for other issues and purposes, and that we will deal with all of the issues that may or may not need to be addressed when we have a de novo hearing. And also, I will note for the record that to address the concerns about irreparable harm, if the parties feel that you're welcome to re-raise the issue of a stay of an underlying order if and when there is an order that may actually prove or cause irreparable harm to, at least in theory, right? At that time.
Okay. Thank you.
Mr. Chair, can I just ask a follow-up question clarifying the concept that's been laid out and Mr. Suazo's question? So as the abeyance moves forward, our applications are paused pending outcome of the underlying applications. Mr. Suazo, I think, articulated, and I think you consented that once final orders in those underlying applications are put in place, and if we assume that those orders are orders that our clients are not satisfied with, then we would essentially resuscitate our applications for de novo review. Mr. Suazo said, and we would then, our clients would then be allowed to present what we hope to present at the underlying applications. My question goes to, would the opportunity to cross-examine witness, so it essentially be the entire case would be brought in front of the commission?
Ms. Hardy, would you like to jump in?
Well, I just wanted to say that we would still object to standing. So I'm assuming we would litigate standing prior to having a hearing on the merits. That's what we would request at that point.
Yeah, it's a de novo hearing. So yes, you could present witnesses, and to the extent that, yes, to both points, right? To Ms. Hardy's point that standing would still be a gateway issue at the de novo hearing. To the extent that you have witnesses to present on the issue of standing, that would be the time to present all of that evidence. Just to be clear, I think that right now we're denying the stay because I'm not finding that at this very moment there's irreparable harm yet. But you are welcome to re-raise that issue when the circumstances have changed. If you feel like the division has, or if you or your client, feel like a division order that is or is not issued in the future may once again create immediate irreparable harm, you're welcome to re-raise that to the commission.
Understood. Thank you, Mr. Chair. I think there's some real prudence in the approach. Just wanted to clarify what the scope, if there was, some alternative new or scope that was being contemplated, but full de novo, including standing, I think makes a lot of sense.
Yeah, really the de novo is for better or for worse. I didn't write the rules, but the rules are very broad when it comes to a de novo hearing. And so really all sorts of things can be relitigated, whether I like it or not. And usually I try to ask parties to stipulate to agree to certain of the underlying parts of the record so we don't have to retread everything. But to the extent that issues are never presented at the division level because of the standing was, denied opportunity, yes, that will be the time to revisit. And if the commission makes a different decision on standing, then we may have a whole different type of a proceeding.
Thank you, Mr. Chair. Appreciate it.
In that case, let me turn back to my commissioners. Is there a motion to approve an order to the effect as outlined?
Mr. Chair, I so move.
Mr. Chair, second.
Thank you very much. We'll issue a written decision to all the parties with all the details. Thank you very much.
Thank you for your time.
Thank you, Mr. Chair and Commissioners.
Let's take another 5-minute recess just to allow people to use the facilities and reorganize. Good morning. If I may call the room back to order. Try to keep us moving a little bit. I now call case number 25875, an application to adopt rulemaking or adopt rule changes related to Class 6 injection wells. And we'll be doing a status conference and consideration of necessary pre-hearing matters and housekeeping matters. I will start with entry of appearances, please.
Mr. Chair, Commissioners, this is Jesse Tremaine for the Oil Conservation Division.
Thank you.
Good morning, Chair and Commissioners. This is Morgan O'Grady with the Western Environmental Law Center, and I'm here on behalf of Dene Care, Earthworks, San Juan Citizens Alliance, Sierra Club Rio Grande Chapter, and the Western Environmental Law Center.
Thank you very much.
Good morning. I'm Samantha Rescavage Bars on behalf of Wild Earth Guardians.
Thank you.
Good morning, Chair, Commissioners. My name is Zach Pavlik.
Oh, Zach, give us 1 second to clarify for the court reporter.
Samantha Rescavage Bars. RUSCAVAGE-BARZ.
Go ahead, Mr. Pavlik.
Thank you. Good morning, Mr. Chair, Commissioners. Zach Pavlik on behalf of the Center for Biological Diversity, and my co-counsel Colin Cox is also online.
Thank you. Any other parties?
Mr. Chair, good morning. Adam Rankin with the Santa Fe Office of Holland and Hart, and with me on the online is my partner, Aaron Tucker for OCC USA Incorporated.
Thank you. All right. I think that's all the parties we have. Anybody? Did I miss anybody? Nope. Okay. Sounds good. I will, before I turn to the applicants, I think just for housekeeping, the commission has already talked about hiring a hearing officer for this rulemaking petition. Our commission and clerk has been able to secure Miss Orth as our hearing officer for this rulemaking. So if there are no objections from commissioners for having Miss Orth as our hearing examiner, may I have a motion adopting that so that we can issue an order?
You want the,
Mr. Chair, I so move.
and I second, sorry. All I heard was, does anybody object to Ms. Orth? And yeah.
Thank you all very much. Is there any objections from commissioners? Hearing no objections, so ordered. Thank you very much. I will have that signed and filed. And I'll turn to applicants.
Thank you, Mr. Chair, Commissioners. We have quite a docket this morning, so thank you, everyone, all the parties and the commissioners and all the preparation. I think I can provide, I'd like to respond very briefly regarding just a status update on the motion to dismiss. And then I'd like to touch on 4 topics regarding the motion to postpone, provide some explanation for the referenced amendments, talk a little bit about rulemaking requirements, discuss the intent and function of the proposed order, and propose some next steps. So it'll be a few minutes, but you can jump in at any point, of course. Regarding the motion to dismiss, we'll be filing a response to that motion in opposition. I expect this week. And we're just, at this point, we're just going to reserve comment for the response. I just wanted to let the commission know obviously what our position is going to be. Regarding the motion to postpone, I want to explain several factors for the commission. So there has been reference and discussion of potential amendments to the proposal. Those were contemplated to potentially come in 2 forms. One, which I'm hopeful we can just simply dispose of and process, is that there are edits which are what I will characterize as drafting clarifications based on comments received. We can amend these in prior to what I understand to be the publication deadline. The second were that I had indicated to the parties that the division was contemplating or previously intending to amend in a section referred to as the New Mexico Program Amendments. This was published in August, I believe August 22nd of last year, for public comment, and is titled Reserve for Proposed New Mexico State Amendments. This section is material that does not get included in a Class 6 primacy application. It is not considered by the EPA. It deals with unitization principles and requirements regarding pore space. This section is the cause of some holdup. The subject matter is relevant to the division's implementation of a Class 6 program eventually, but the technical and legal basis are adjacent to what's in the current petition. There would be different witnesses, and the focus of that is on fair and equitable treatment of pore space owners, not well construction, operation, protection of correlative rights, prevention of waste, and critically protection of groundwater. That is factored into the current petition. So the department is not proceeding with an amendment on the New Mexico Program Amendments. We are not seeking to add that to this rulemaking. I'm working with leadership to identify the best path forward. If that is necessary in the form of a rulemaking, we're talking about a separate petition that would require 1 day, 1 to 2 witnesses for OCD, something that's relatively easy to schedule, relatively easy to schedule in the future. So I wanted to clarify that, the subject matter of that, the reasoning, some of the reasoning for abandoning that plan. In terms of the proposal to postpone both the scheduling, the pre-hearing schedule and the actual hearing dates, I want to back up a little bit and talk about the actual rulemaking requirements here. So in 19.15.39, the notice has to go out 30 days before the hearing. If we move forward with a notice that is published on June 9th, that's going to be 1.5 months more than that before the hearing. Our actual rulemaking rules are structured for live testimony. Technical testimony is required 10 days before the hearing. So I just want to set that as a backdrop, because while the division has in the past, and in this case is agreeable to the structure that was proposed and discussed among the parties, those are extra regulatory procedural requirements. Our rules require us to submit a pre-hearing statement 10 days before, show up with our witnesses and exhibits, and present our testimony. So we are agreeable with moving forward with pre-filed direct testimony. But I want to clarify that contemplated procedure involves prep and filing of testimony over a more than 2-month period of time. And everything that we've been doing, as I said, procedurally is in addition to the commission's rulemaking rules. That's fine. And if that process is helpful for the commission, we will agree to that. We've seen different versions of that. Rulemakings prior to, I can't remember the case number, the PFAS rulemaking, were all done, to my knowledge, live testimony, normal hearing procedure. We tested out a process with live pre-filed direct testimony in that rulemaking, but there was not pre-filed rebuttal testimony. The last rulemaking, which we've discussed at length, was quite adversarial during the rulemaking. There was a clear benefit to having pre-filed rebuttal testimony. I'm ambivalent as to whether or not one is better than the other. If I had my druthers, I think we would show up and do live testimony. But if it's helpful to the commission, we're happy to proceed with that. So the timelines are obviously getting tighter at this point. But that's because we've contemplated adopting such an expansive rulemaking procedure. So I think the remedy here, appropriate remedy, is to adjust the timelines in consideration of the publication dates. And look at delaying direct until a later date and set rebuttal closer to the hearing or forego pre-filed rebuttal. A quick note on the proposed hearing procedural order. I think filing that this week with the highlighted sections left some questions. The intent there was to simply highlight for the commission's ease the sections that were either unresolved or in dispute based on the pending motions. All right, so these were dates that I had adjusted based on discussion of the parties who had participated in that discussion prior to the new parties who've entered appearance. So those are all placeholders, but they approximate, and I think Ms. Morgan and I are off by like 1 or 2 days on 1 or 2 of those, but we're approximating the same dates that we had discussed previously. So to clarify that position, I am suggesting that we amend or change those filing deadlines to meet the, whatever the commission feels is appropriate for those pre-hearing filings.
Can I take things one at a time?
Sure.
So first, the motion to dismiss, the briefing, there's already briefing schedule, and that briefing doesn't conclude until June 3rd. So that's not ready to be heard today, but that should be heard at the next regularly scheduled commission meeting. Is that correct? Any objections to that from any party? Okay. Briefing schedule on the motion to postpone. There is no briefing schedule yet. In order to try to move things along, I think I would be interested in a slightly expedited briefing schedule for that. Can I get some suggestions on proposed dates for the response motions and deadlines for the replies?
I can consult my calendar here. I think my intent with this explanation, Mr. Chair, is to ask the commission to adopt a procedural order today that is fully compliant with the rules by proposing different filing dates and resolving that. The distinction I'm making, and so I'm making an oral motion rather than filing a responsive motion, but I can do that in writing if the commission so chooses. But that would cause a delay in resolving that issue to June. I think the operative issue here is that the publication, the notice publication needs to go to the New Mexico Register on May 22nd. So I think you should hear from the parties and change the pre-hearing procedure filing dates,
Okay.
but keep the hearing as scheduled on July 27th. And all of that is in full conformity with the rules, and it can be accomplished even adopting the full process that we've laid out here.
Can I ask a question? So my understanding of the law is that 30 days in advance, something's published and the public can hit a hot link that they see on that notice, and that is the lockdown rule. So the public is prepared. So you just said you now want to do the notice this month. Is the rule going to be locked down this month?
Yes, the rule will be locked down by the end of the week. And that's why I went into the explanation, Mr. Chandler, there. We're talking about punctuation changes. There's an and, a switching to an or. We're not talking about substantive changes from the reserve sections 1, 2, and 3, which have been publicly noticed and available for public comment since August 22nd of last year. I understand that's distinct from publication in the New Mexico Register. My understanding from speaking with the clerk is that deadline for publication is the 22nd.
So that's good because the motion for postponement says there's a new part. So I think you've now clarified on the record what this new part is. Okay. So that is the statutory requirement, the 30 days. But this is 2026 and everyone's lawyered up and they're expert up, but that takes a long time. So it requires more lead time than the statute requires. And so are you adjusting some of the dates and saying, well, we're going to give you 2 months to get your witnesses together and all that stuff, but we're still meeting the statute with at least 1 month advance?
We will exceed the the rule notice requirement substantially. I haven't done a day count, but it would be between 45 and 60 days, I believe, if it's published on June 9th. So what has happened in previous rulemakings, and I think it is relatively normal that things get amended during that process, is that the rule is often noticed, and then if there's changes, there's a notice there. We've discussed and the commission determined appropriate dates for scheduling a 2-week hearing some months ago, and I believe the commission adopted that. The pre-hearing procedures, which I will reiterate, are well above and beyond the rulemaking requirements, are what we're contemplating today. Now, in terms of parties entering appearance late in that process, certainly I want to make sure that Wild Earth Guardians and the MOGA and any other parties that appear have an appropriate opportunity to prepare and respond. This was actually set and contemplated for hearing quite a while ago, and we moved it because of parties and delayed it substantially because of parties that rather than schedule it when the division proposed, which was in spring of this year, we provided something like 3 or 4 months for the other parties that were attending at that hearing to get their witnesses and prepare. So we provided that opportunity. I don't know what the commission wishes to do if parties are entering appearance in the 2 months prior to when it's scheduled the hearing, and then if they're going to ask for more time.
My final thing, I imagine you're very busy. You didn't watch the Water Quality Commission yesterday where Commissioner Brankert said the logical outgrowth rule has been thrown out and overturned. So he put the environmental bar on and the administrative bar on notice. So that might be something to look at as you lock down your rule, how locked down it is.
Thank you. And forgive me if I'm being dense here, but I'm looking at 2 different things here, right? I'm looking at one is the proposed scheduling order for the whole thing, but we've also got a motion in front of us to postpone, and it seems like we need to resolve the motion to postpone, or else that could change everything in the scheduling order. So that's why I wanted to address the motion to postpone before addressing the highlighted dates in the scheduling order. And did I hear you say, Mr. Tremaine, that you want to waive responses to the motion?
I don't want to wait. Well, I'm making an oral motion today because I'm trying to expedite for all parties' benefit the schedule while preserving the extremely challenging to schedule 2-week hearing based on party and commission availability. So what I am proposing that resolution, if the commission adopts it, is contingent upon acceptance of proposed changes to the order that I'm bringing before you.
You're making your own motion, oral motion.
Well,
now I have 2 competing motions. I'm lost.
I am responding verbally to the motion to postpone because I haven't had time to brief it.
Sure.
If the commission buys my argument and the plan that I'm putting forward, we won't need briefing.
Is that the same position for all the other parties?
We have a few, Chair, Commissioners, we have a few points we'd like to make in response, if you're ready to hear them.
Sure.
So First, we do agree that 1915-3-9 NMAC simply requires 30 days notice before the hearing, and that pre-filed testimony is not a requirement in this forum. However, parties did agree to pre-file testimony here, and the Oil and Gas Act requires reasonable notice, which here we think requires notice of the deadlines for submitting testimony. Second, regarding a compressed testimony filing schedule, which I believe is what Mr. Tremaine proposes here, parties agreed to a month between each testimony filing deadline and then a month between the last one and the hearing. And we think it's fair and reasonable to maintain that spacing of deadlines. Third, just a note about the efficiency of the commission's time. We would rulemaking at all. Thank you.
Mr. Chair, I would have to dispute and object to setting, moving the rulemaking or vacating those dates based on a dispositive motion. We've seen dispositive motions in, I think, most of the rulemakings we've conducted, and kicking the dates for the substantive rulemaking off the calendar because so what's going to happen here, Mr. Chair, is that we respond. I believe the deadline is in the 19th. I can't recall offhand what the deadline is for the response. If you don't resolve the scheduling issues separate and apart from the motion to dismiss and remove this rulemaking from the calendar, it's going to get kicked out indefinitely. And then we're going to be back here, I don't know, December 2027. And that, I don't think that's an efficient use of time either. I think these are two separate issues. In each rulemaking I participated in, the commission has handled dispositive motions in stride, but moved forward with the substantive matters.
We have a briefing schedule for the motion to dismiss. So that's just out there. I don't have a briefing schedule on the motion to postpone. Is the request that we rule on the motion to postpone today without further briefing from parties?
I will act in conformity with the commission's wishes. It sounds like it may benefit the commission to have a written response deadline. My goal is to propose practical changes to the pre-hearing procedure, which, as I said, conform with the rulemaking rules, and I think satisfy the commission's and the parties' needs. I understand.
I'm sorry. I just wanted to note the audio is cutting out and
My
online we're
apologies.
not able to.
My apologies. I'm apparently struggling with buttons today. The question was whether any party, I just want to preserve everybody's due process rights to respond if they wanted to the motion to postpone. But it sounds like, at least here in the room, everybody seems ready for the commissioners to rule on the motion to postpone. And nobody is speaking up to ask for a scheduling order. So, Mr. Pavlik, are you also ready for the commission to entertain the motion or and dispose of it one way or the other, or would you like opportunities to further brief?
Thank you, Chair Chang. I think, there could be a benefit to a briefing schedule. I agree, though, it may not be necessary in this instance. I would note, though, that there's, as part of the motion to dismiss, there is a motion to stay deadlines, which could work in terms of consolidating the two motions together on the same deadline and briefing schedule. Something that we would suggest would be on the June 11th meeting. That would be a natural time to discuss deadlines and prepare final dates, just because we would have the briefing schedule that would be completed for the motion to dismiss. Whether the motion to postpone is resolved today or on a different schedule, that would allow time for that to resolve itself. And I'll note also that June 11th is a deadline for filing in the New Mexico Register. That would allow both of these motions to play out and then would provide OCD an opportunity to notice dates that the parties could then discuss at that June 11th meeting and properly move through, I think, the rulemaking at that point with whatever deadlines seem appropriate after both motions have played out.
Okay, thank you. So I'll turn to commissioners to look at your, if we could look at calendars and sounds like at least one party would like to brief. So I'm going to at least entertain that opportunity. But it doesn't sound like it. Do we need both responses and replies, or should I just set, any additional briefing on this shall be done by June, June 3rd? And just leave it there? How does the commission want to proceed here?
Mr. Chair, so I certainly would like us to pick up those two issues on June 11th. So if it is June 3rd for the filings, I do not have any problems with that.
Okay. I'm willing to allow, simply for the purposes of moving, limiting it to just one further filing from anybody, if at all, unless the movements want to preserve the opportunity for a reply.
Mr. Chair, June 11th would work for me, if you didn't want to go earlier.
How about this? Can I say May 22nd for any responses and May 29th for any replies? That way we're set up to rule on it in June. Does that work? I'm not seeing howls of protest.
So, Mr. Tremaine, do you understand what they're putting you through here? Like June 11th is the last day for you to submit the notice to meet the 30-day in advance.
No, I understand that, Mr. Chandler, and I understand part of that. The commission publishes notice, so in the New Mexico Register. So we will amend the petition this week, so it is ready to go in. My understanding from speaking with the clerk is that to get it in the register, I've seen different dates, but in talking with Sheila, I believe it's June 9th. So if it's June 11th, that's a different date and we can figure that out. I was told May 22nd is the filing deadline.
Okay.
So we will facilitate all of the other notice as normal, but the publication goes through the commission clerk.
Now, you could tell me we're going to publish the notice in 2 weeks. We're not going to wait till June 11th. We'll just, so I don't want to put words in your mouth, but so what is your plan for publishing the notice?
That is exactly my plan, is publishing the notice by that May 22nd date. If we have that wrong, it'll be a different date. My only hesitation is I don't supervise or tell the commission clerk what to do. So I will coordinate, and my assumption is that she will be able to comply with that requirement. The motions will not be resolved by that date based on this reply schedule. So I will be moving and requesting the commission and the clerk to publish that rule in advance of resolution of these. Obviously, if the moving parties prevail, then that comes off the books. But it needs to go to the New Mexico Register on whatever that date is. My understanding was May 22nd.
Okay. So now let me turn to the scheduling order with the yellow highlights, which is your proposed scheduling order, Mr. Tremaine. Are there any dates that need to be adjusted at this point? Understanding that, of course, should motions prevail, that they all may change.
Yes, Mr. Chair. So on page 1, my request is and will remain that the hearing date remains the same. The second highlight will need to be changed to, according to Mr. Chandler, June 11th.
Hold on. I'm not a party. Okay. So you can publish whenever you want. I would advise when the rule is locked down would be the best for the public. So when they hit the link, they know what that is. Okay. But you don't have to wait till June 11th.
Certainly not. No, the issue here, Mr. Chandler, is that the publication goes to the New Mexico Register, and then there's a delay before they publish it. So we have a deadline. So I'm referring to when it will actually be published in the New Mexico Register, not when it is submitted to the New Mexico Register. So this language refers to its publication, not when we send it to them. That's why I keep referring to that publication date. So
May I interject quickly?
Yeah.
Apologies. I think that there are two potential dates that could, where it could be submitted to the New Mexico Register. There's a May date that would publish in early June, and then there's a June date that I think aligns with the June OCC meeting that would result in a late June publication date, which would still be 30 days from the hearing itself, although presumably after testimony filing deadlines, depending on the dates we land on.
Thank you. Ms. O'Grady, what I'm trying to avoid is the issue of publication in the register after any potential date. So we are going to have this to the register for the earlier publication date. But as far as how this is drafted, which was based on the procedural order from the last hearing, the amended procedural order from the case we're hearing this afternoon, that refers to actual publication in the register. So we will need to amend that date. What I am proposing.
We're trying to type this down as you talk. So let me go back. So the first date is still July 27th, 2026. Is that correct?
Correct.
Okay. And the second date, instead of May 20th, 2026, what are you now proposing?
My understanding from talking with the clerk was that was going to be June 9th. And I understand that Mr. Chandler's not a party, but he raised the notice of the schedule so that may be June 11th. We will double check that.
No, she corrected me. There's two different dates. It's right here on the schedule. June 9th is the date it would be published. Okay, so
Okay.
You're correct.
Thank you. So that the second highlight will be June 9th.
Okay.
The third highlight would remain today's date because this is the contemplated scheduling unless you change that. In paragraph 3, and this is where I'm proposing choices for the commission. So I think we have two options. We can delay both dates and hold the rebuttal deadline closer to the rulemaking date, which would change paragraph 3 to either June 22nd or June 29th. And then the rebuttal testimony in paragraph 4 could be July 13th or July 20th. The other door 2, which I raised earlier, is that, and I agree with Ms. O'Grady that the parties all agreed to this in principle, but it is, as always, subject to the commission's approval. So if the commission wants pre-filed rebuttal testimony, if you prefer that and find it helpful, these are the dates I'm proposing. The other option is get rid of pre-filed rebuttal testimony. I agreed to it in principle. I found it, I think, helpful in the last rulemaking. I did not feel in the previous rulemaking that it would have had a benefit. So I think that's up to the commission. If we if we want to provide the parties more time, I think the most time, particularly to allow Ms. Rescavage Bars and counsel for Namoga even additional time, getting rid of the rebuttal testimony and putting the pre-filed direct testimony deadline on one of those dates in July could be preferable.
So parties weigh in. What do you guys want? Because the commission has I'm sure the commissioners may have preferences, but ultimately y'all are the ones that need to live with these deadlines.
Thank you, Chair. Chair, Commissioners, we, as we stated before, would like to maintain the gap between each deadline that we agreed to back in the spring.
Please.
Well, there's a lot going on here, right? I think from Oxy's perspective, what we don't want to be is in a situation where we're trying to, it's a fairly extensive rule, and we don't want to be, and it's important to Oxy, okay, to be able to have a CO2 sequestration rule. We don't want to be in that it work properly. So we don't want to be in a position where we don't have the time to properly respond in advance of the hearing. So if, given the status, and if it's likely that the hearing is going to be postponed, we don't want to be crunched to present our testimony. And we do believe that there's a benefit to pre-filed written rebuttal because it gives the parties the opportunity and the commission the opportunity to fully vet the issues at a hearing. So our preference would be, it's given the timeframes, I think it's important to maintain just enough time that we have the opportunity to not be crunched. So I'm trying to be gentle here because I don't want to come out. We don't have strong opinions about this, but we do think, given the status, probably a delay would make sense, especially just so that the parties have time to respond in testimony and written testimony, especially. So my concern about the scheduling order is simply that we don't lose the time for written rebuttal.
I appreciate that. It sounds, I'm just trying to put down dates in an order here. So I'm just looking for specific dates. If parties aren't ready for that, do you guys want to meet and confer and go through your calendars, pick dates and come back to us? Because it feels like I'm getting a lot of vague and not doesn't sound like we've got everybody on the same page with like specific hard dates that they're ready to recommend to the commission.
Mr. Chair, if I may, the ask in the motion to dismiss and the motion to postpone in conjunction with the ask to maintain 30 days prior to the, have direct testimony filed after notice, publication in New Mexico Register, and 30 days, once you factor that in, 30 days between direct testimony and rebuttal testimony, and then 30 days between rebuttal testimony and the hearing those are not compatible. I don't believe we can publish in the New Mexico Register and then have 30 days between each of those events. To keep the July 27th date, there is not enough time. So I understand the ask to be that the direct testimony deadline be after, if not 30 days after the publication date. So I think the commission is ultimately going to need to rule on the motion to postpone and select one of these options, because I don't see a path forward to fit 60 days in between the publication deadline and that. Am I misstating the request?
No, you're not. And we do acknowledge that if we maintain these, the briefing or the deadlines that were agreed to, it would push out the hearing. However, I do want to emphasize that until recently, we did believe we were adding another part to the rule, expecting some drafting changes. Testimony, we've understood direct testimony to be due at the end of this month, and we're midway through the month and we've been waiting on these changes. However minor, it does impact the way our experts are drafting their testimony. We're in the unfortunate position of having to ask for delays at this point to comply with notice requirements as we believe them to be reasonable, and also to make sure that we have what we need before us to do the direct testimony or to organize that testimony. And that at this point, it looks like that may push out the hearing dates, unfortunately.
So, we just had the conversation a few minutes ago about whether or not we can rule on the motion to postpone when both the motion to dismiss and the motion to postpone are not ready to be acted on. So I think my ask right now is to have dates for a scheduling order, without those if we were to rule in favor of those motions, then we would have to redo a whole schedule. But for now, since we haven't taken any actions on that, can we set a scheduling order, with at the current status quo, which is no postponement and no dismissal, right?
Yes, I think that the difficulty, the impasse that we're at is that some parties would like to maintain the gap between each deadline. And I recognize that the division would like to maintain the hearing dates that we had agreed upon and anticipated. I do wonder if this might be a matter that would traditionally be discussed with a hearing officer, who unfortunately we haven't had appointed yet until today. And I think that might be a better use of the commission's time to have us hash out those dates with a hearing officer.
I think that's probably my favorite suggestion of the day. So, any objections from parties that that the commission asked you to revisit this at a status conference with the newly appointed hearing officer?
No.
Hearing no objections?
No.
Commissioners, is that an amenable plan instead of us trying to?
That works for me, Mr. Chair. Thank you.
Works for me. Thank you.
Okay, well, in that case, I will entertain a motion to have the parties take up scheduling at a status conference with the hearing officer at the hearing officer's earliest convenience.
I so move.
I second.
Any objections from commissioners? Hearing no objection, so moved. Thank you all so much. Thank you all very much. I now need to get back to my agenda. I'll call case numbers 25694, 25695, 25696. Actually, let me ask commissioners, would you like to break for lunch now or get through this?
It's 10 minutes to 12.
This case is American Energy.
Yes.
I say we break now and come back.
Okay.
Yes, thank you, Mr. Chair.
All right. Given the preferences of the commissioners and given the current hour, we will take a break for lunch and come back at 1 p.m. And resume the agenda at that time. Thank you all very much.